Welcome to session 20 of ID24. Up next, we have Lainey Feingold. Lainey is a disability rights lawyer in the US. It would take far too long to go through all of her accomplishments in this short introduction, but among the many things Lainey is known for are her legendary annual sessions at the CSEN conference. And as I've never been able to get into one of these sessions because they fill up so fast, I'm particularly excited that we have her to speak to us at ID24. As usual, if you have any questions for Lainey, please tweet them with the hashtag ID24. And so now, Lainey, over to you.
Okay, thank you. Thank you for that nice introduction. And thanks for having me as part of ID24, which has been great so far. Okay, so this session is called Beyond Compliance, Accessibility as a Civil Right. And I have my name up on the title slide and my Twitter, which is LF Legal, and my website, which is lflegal.com. There's a lot of accessibility resources there. And I invite you to investigate them and contact me if there's any questions on the contact page. So those of you who have heard my CSUN sessions and other sessions know that I'm a big believer that we all need to put the law in our pockets, and that the law isn't just for lawyers, and that no matter what role you have in the accessibility world, and this whole 24 hours has been devoted to all the roles that make accessibility possible. No matter what your role, I think it's important to know what the law is and how it impacts accessibility, and think about how do you talk about the law. There's a lot of fear associated with law. People hear about lawyers and they think, oh no, what did I do wrong? Am I going to be punished? Is it going to cost me money? So I am interested in trying to shift that, so those of us in the accessibility space can think about the law as a motivator. Because, as I hope you'll agree by the end of this 50 minutes, it is really great that we have the law that recognizes that disabled people have access to technology. So how can we shift this culture of fear around the law, especially in the United States, especially the last 3 years? How can we shift that? Can we shift that to thinking about the law as motivation? And so when we take the law out of our pocket, those of us who are committed to accessibility, can we take it out in a more shining, affirmative way? So that's what I try to do, and that's what I'm trying to give over so we all can do it together. And the reason I think we can shift it is because at its core, accessibility is a civil right, accessibility is a human right. And I illustrate this slide with a picture of a protest march, demonstration march in the run-up to the Americans with Disabilities Act in the US, and there are disabled people holding up a banner, "Injustice anywhere is a threat to justice everywhere." And that's a Martin Luther King quote, Martin Luther King Jr. quote that was adopted by the disability rights movement. And it's this kind of activism and the quest for civil rights and human rights that brought us to the ADA, and that brings us to accessibility as a civil right or a human right. I use those terms interchangeably. I know in outside the US, more frequently, rights are referred to as human rights, civil rights. In my mind, they're the same thing. And the reason is, I say why here on the slide, like why is accessibility a civil right or a human right? Because with accessibility, we have participation, we have inclusion, with the emphasis on the in, and we have equality. And this is illustrated by two people talking. One person has Down syndrome, the other person is visibly disabled, and they're just walking down the street trying to be friends, laughing over a joke. So at the legal core of the right to accessibility is a right to participate, be included in equality. And the opposite of that is true too, that without accessibility, people are left out, like the picture of this woman sadly looking into a window that she's left out of. There's exclusion instead of inclusion, and there's discrimination. And that's really why accessibility is even in the legal space, because without it, people are excluded, left out, and discriminated against. So it's basically a simple equation. Accessibility is inclusion. The lack of accessibility is exclusion. So that is the core of the legal issues. So why is accessibility a civil right? Because we're talking about the right to information. All of you who are listening to this, who are designers, developers, coders, head of accessibility teams, UX teams, testers, whatever your role is, you're providing information about your product, your service, government agency, education. So accessibility is integral to information about education, transit, voting, and other types of services, and the law impacts all of that. And similarly, accessibility is a human right, a civil right, because it's about participating in education, the private sector, the public sector, and the social community. And like Cynthia just said in her presentation on Starbucks usability plan, it's about getting coffee and being able to get coffee by yourself independently. And the law helps with that. And so why should we be afraid of it? I mean, it is very good to have laws that recognize that we want a society where everyone is included, regardless of whether they see a screen or hear a video or use a mouse. So that's one way to take the fear out of the law. It is the core value of integration and participation that is nothing to be afraid of. So how do we put the theory of civil rights and human rights into the practice of accessibility with the law? The way it basically works is there's the foundation, which is laws and regulations, and there are the advocates, the people who use those laws, and there are the strategies, the way people use the laws, and that all adds up to access wins. And that's what I want to talk about next. So we have laws and regulations. I know there's people from all over the world listening to ID24, so obviously different countries have different laws. We'll talk about that in a second. The advocates, the who is so important. You know, that's another part of the fear factor is when people talk about the ADA, they're just, you know, mainstream media talks about, you know, lawyers who are just in it for the money. But the truth is all the good accomplishments that the law has brought to accessibility has been brought because of advocates in the disability community, blind people, deaf people, people who need the information that you all are providing through your webs and web and mobile apps. That's a critical part of the equation. The laws, the advocates, and the strategies that lead to access wins. So the law is the foundation. And I have a picture here of a strong foundation being built with cement blocks and a lot of tools. And that's the laws and the policies, the foundation of all advocacy. So in the United States, we have the Americans with Disabilities Act. It covers the public sector. It covers the private sector that deals with the public, like banks and stores and financial institutions, health insurance companies, anything in the private sector that's interfacing with the public. Covers employment of disabled people. We have a different law requiring accessibility for federally funded projects. If you're getting money from the federal government, that money is for everyone in the public, and the public includes disabilities. So there's a non-discrimination law for that. Federal employment, which they call Section 501. Again, this is kind of a lightning talk, or a lightning, what's the word I'm looking for? It's a quick overview of the laws and policies. I should say that even though I'm a lawyer and I'm talking about laws, this isn't legal advice, and the laws around digital accessibility, like for example, the ADA has been interpreted by courts, by the Department of Justice, by many, many of our negotiating partners to have web accessibility required, but it doesn't say, there's no language in there because it was written in 1990. So don't take any of this as legal advice. If you have a legal problem around accessibility, you need to call a lawyer. But this is just an overview of part of the foundation in the US. There's a separate law requiring airline websites to be accessible. We have the 21st Century Communication and Video Accessibility Act, which they shorthand refer to as CVAA, that deals with browsers and the on-ramp to the internet. I put this up here, the Workforce Innovation Opportunity Act, which is just, you know, a small law dealing with centers around the country to help people in employment. Those have accessibility requirements. So we have a lot of strong laws and policies in the United States supporting participation, supporting inclusion, supporting non-discrimination, and that all means that they support accessibility. But do we have web regulations? Do we have any specific regulations that say your website must meet WCAG 2.0 AA? The answer is we do not. And I have a big red circle crossing out the words ADA web regulations. The Obama administration was not able to get regulations out. We certainly should not be holding our breath to see any regulations during a Republican administration. Technically, there's still a date of 2018 for the possibility of regulations. I wouldn't bet one penny on that, but it doesn't matter. And that's, again, a way to talk about the law when you take it out of your pocket. You have people jumping on the bandwagon saying that, oh, accessibility law is a gray area. We don't know what to do, so we shouldn't do anything. Well, that is a terrible thing to say, and it's not a good idea. It's not smart for business, and it's not true because, like I said, the Americans with Disabilities Act and these other foundational laws are all about inclusion and participation. 21st century, you cannot have inclusion and participation without accessibility. In addition to all the federal laws in the United States, many states have laws. I have a picture here, a United States map with every state a different color because, in fact, it's really a patchwork. Every state has different types of laws and the kinds that affect accessibility. Most states have requirements that state-funded IT has to be accessible. Most states have procurement laws saying if that state agency is going to buy a product or service, build a website, whatever, it has to be accessible. And most, not all states have anti-discrimination laws. And most, not all states either, I don't think anybody specifically includes web accessibility in those anti-discrimination laws, but like the ADA, those are laws that require participation and prevent exclusion and require effective communication. We do have a new situation. One state of Oklahoma recently specifically said websites weren't covered by their state law, and other states are thinking about limiting their state laws as applied to websites. So that's just a heads up that whatever state you're in, if you're in the United States, it's something to pay attention to. And there's also local laws. Many progressive cities, New York City has an anti-discrimination law. So there's lots of different pieces of the foundation. Beyond the United States, we have the CRPD, the Convention on the Rights of People with Disabilities, that specifically has a section about the importance of accessible information technology. The W3C Web Accessibility Initiative site just yesterday, I think, or the day before, updated their international page. You can find it at w3.org/WAI/policy, and they have the current policies of many countries around the world. Thank you to WAI for doing that. And on my website, I do have a page where I try to keep track of what's going on internationally. You can find that on my website at lflegal.com. The easiest thing to do is search for the word Japan, and then it will pull up. The full URL is 2013/05/GAAD-legal, because I initially wrote it for Global Accessibility Awareness Day in 2013. And I keep it up, but now that the WAI policy page is kept up, I'm going to try to have better integration on that. So that, again, is about the foundation, the first part of the equation to recognize the civil rights that are so much a part of accessibility are these laws all over the world. But without strategies, that foundation is only that, a foundation, which is what this picture is, a foundation with no building, which doesn't do anyone any good. So you need strategies for accessibility, strategies implemented by disabled people and by their lawyers. So strategies for enforcement of the law. I have a picture of Toolbox. And when I do this presentation in person, I actually carry around a toolbox. I'm a big believer in the toolbox because there's lots of different strategies that have been effective. and the law is flexible that way. So that's another thing. You know, you're going to hear, we got to limit the law. There's too many lawsuits, blah, blah, blah. Well, first of all, as we'll talk about in a minute, lawsuits have been critical for advancing accessibility in the United States. But two, there's a lot of different tools. And when you talk about limiting a law, you're talking about limiting all those tools. So it's really important to recognize that the law as a foundation is strong, shouldn't be tampered with. And there's a lot of different strategies that we've been using. I've been involved in this space since 1995, and there's been a lot of different strategies that have advanced accessibility. So what are the legal strategies in the US? There's three. Federal agency complaints have really made a big difference in accessibility. I have a question mark here. Is this still going to be the case in the current administration? We'll talk about that in a second. Lawsuits have been an effective strategy in both federal court and state court, and structured negotiation has been very effective in accessibility strategies. We'll talk about structured negotiation in a minute. That is the way I practice. That is a strategy that I've used. I said 1995, just for those of you who don't know me. That year, representing many blind individuals, my colleagues and I wrote letters to Bank of America, Wells Fargo, and Citibank. And those letters said, you know, there's not a single ATM in the whole United States that a blind person can use. This violates the ADA, but we would rather not file a lawsuit. We'd rather sit down and talk to you. And that way, blind people would have input in the solution, and a lot of money wouldn't be wasted on procedural arguments. And that worked. And we worked with Bank of America, Wells Fargo, and Citibank on talking ATMs. And towards the end of that discussion in 1998, I think, all of a sudden, our clients came to us and said, well, it's great. We have talking ATMs now, or they were, you know, on the horizon, but there's this new thing, online banking. And that has to be accessible, or we are going to be excluded and locked out, just like we are from ATMs. So we went to Bank of America, and we didn't have the name structured negotiation. We just knew we had a relationship with the bank and that their teams were committed. And we said, you know, there's this new thing. It's online banking. We got to make sure it's accessible. And in 2000, Bank of America became the first bank in the country to commit to online banking accessibility, and was actually the first settlement agreement in the United States around accessibility. And because that was so successful in getting real buy-in, and yes, it was the law that made that happen, but the lawyers could take more of a back seat, we decided we need to name this thing. And so we named it structured negotiation, and the rest is kind of history, which we'll talk a little bit about in a second. So the first strategy, government agency activity. The Department of Justice has been a true hero and champion of accessibility throughout the Obama administration. Obviously, the leadership has changed significantly. There have been no new developments out of the DOJ on accessibility since the new administration, which is kind of good, because that means there hasn't been anything bad happening either. So they have a web page up, which I have a screenshot of here. It's ada.gov/access/technology. Whenever I do a presentation, I like check beforehand, like, oh my God, let it still be there. And it is still there as of yesterday. And on this page, you can see all these settlement agreements, and the DOJ has gone to court, and they've really established a foundation that the Americans with Disabilities Act covers websites. So we may not, and we probably won't have a lot of activity under the new administration, but my bet is very unlikely that this can be undone. It certainly can't be undone in the courts in the next 3.5 years. State Attorney Generals, Massachusetts Attorney General in particular, has done a lot of great work with the National Federation of the Blind, using the power of their office to get companies and schools to do accessibility. Most recently, they did a great agreement with a kiosk company in the healthcare space to make sure their kiosks are accessible. And the H&R Block case was also brought by the State Attorney General of Massachusetts. Department of Education has done a lot of work on accessibility with schools. And last time I did this presentation, I said, well, I don't know if they're still doing things under the new administration. And someone in the audience said, yeah, they are still enforcing the laws because colleges and universities are covered by the Americans with Disabilities Act, and the Department of Education has done that. So that has been one of the strategies that's been effective. We have to kind of see what's going to happen with that going forward. Strategy number 2 has been lawsuits, and just really quick, there's been many successful lawsuits that have really moved the needle, pushed the ball down the field, whatever metaphor you want to use, in terms of advancing accessibility. So some of the best ones, and I guess I should say here that I do these legal updates, as webinars or live talks, but I also on my website have an update tab, and on that tab, I take what's in the presentation and write it up as a website post with links to the agreements and the press releases. So I usually say that at the beginning, so you don't have to furiously take notes, because everything I mention is either in the most recent updates or will be in the next update. And on my website at lflegal.com/contact, you can sign up for my email list if you want to get notified when I put a new one up. So Netflix was a lawsuit that brought by the deaf community. Again, it's all about the advocates that the streaming content on Netflix had to be accessible. Really important lawsuit against Miami University, Ohio, that deals with all aspects of educational technology, websites and mobile course materials, massive online courses, classroom technologies, things like that. Harvard and MIT, there are lawsuits pending over captioning of video that Harvard and MIT post on their website. That case is moving forward. They've tried to throw it out of court a couple times and have failed. The Harvard and MIT are on their 3rd set of lawyers. The case is moving forward, and the current status of it is that it's in mediation, where hopefully the parties will come to a resolution. There's been a lot of important lawsuits. Again, we're talking here about how can we shift consciousness about the law and not talk about it from a fear factor. There's a lot of lawsuits around the right to vote, and if websites and absentee ballots and everything with voting machines, everything related to voting is not accessible, then disabled people do not have access to vote. So when people talk about being afraid of the law, I like to say, well, without the law, without lawsuits, there would be far fewer accessible voting websites and information. There have been cases in New York, in Ohio, in California, all at this stage brought by blind people, making sure that voting's accessible. And more lawsuit wins. There's a case in Arizona brought by the deaf community so that people have access to text to 911. That was a lawsuit, again, emergency. There's also been emergency preparedness lawsuits to make sure emergency information is accessible. Again, these are examples we can all take out of our pocket if people say, oh, there's too many lawsuits. Well, we'll talk about in a minute some of the new players jumping on the lawsuit bandwagon, but there are so many more reputable lawyers representing reputable clients using the law in a really effective and important way. So text to 911. There was a lawsuit in New York City to make sure their public kiosks are accessible. I have a picture of one of those up here. They're just kind of like the modern phone booth. You can plug in your phone, you can charge it, there's USB power, you can call 911. There's a lawsuit about that. To Cynthia's point that people need independence when drinking coffee, there's a lawsuit that was favorably settled to make the Sweet Green restaurant chain's website accessibility, because they offered a lot of online ability to order in advance, and that wasn't available. Law's been effective in helping students there's a picture here of a chiropractor. There was a case where a student couldn't take the chiropractic exam. I think it was in Iowa because that wasn't accessible. So when people talk about the law, these are all, These are all what we talk about when we say civil rights. It's not an abstract thing. It's about a person who wants to be a chiropractor who is blind. It's about a deaf person in an emergency who can't call 911. And that's what we mean about civil rights and the law. Strategy 3 is, of course, the one near and dear to my heart. I did just write a book on this called Structured Negotiation, a Winning Alternative to Lawsuits. It's not just for lawyers. And in fact, I really always thank Whitney Quisenberry, usability expert, who gave a really nice review of the book and its usefulness to people working in teams. And it's all about the strategy, full with stories that I've used since that first Bank America case to work with big companies. So some of the structured negotiation wins, we recently did an agreement with HEB Pharmacy in Texas about talking prescription labels, and that was the most recent. We've worked with CVS and Walgreens, again, with no lawsuits filed, in order to make sure that their prescription labels can be read by people who are blind, seniors who can't see a standard label. Major League Baseball was a really effective structured negotiation. Why? Again, because the advocates. Structured negotiation, instead of suing Major League Baseball, we connected Major League Baseball and blind baseball fans, and bingo. And that's why, you know, again, to Cynthia's point about doing the usability testing at CSUN, it is my experience that when the teams and even the lawyers and even the risk management people, when they can meet disabled people in a, I want to say peaceful, but like a non-conflictual environment, people understand that accessibility is a civil right. And when I first worked on it, I talked about this in the book, when I was first called by some of the blind fans about working on Major League Baseball accessibility, you know, I had mostly worked on healthcare websites and banking websites, financial privacy, issues where privacy, you know, privacy is so wrapped up in accessibility. And that's another civil rights aspect, because without accessibility, people cannot do things independently. So, you know, check your account balance on a bank. You don't want help for that. Or check your medications. We did a deal with American Express early on, and I think it was successful because our clients, who were like super nice and friendly guys, Paul Paravano was one of them from MIT, he's a blind guy, he told the American Express people, you know, I have a great marriage, but I don't want my wife to see what I spend on my American Express card every, you know, time I travel. So it was, you know, a little bit jokey, but a little bit, that's what did it. People got that. When people can communicate with each other, I think that's why structured negotiation has been successful. The companies and the government agencies can see why the law is needed here and why this stuff is civil and human rights. So we've done structured negotiation with Major League Baseball, with Anthem Blue Cross, San Francisco Federal Credit Union recently. I was not a lawyer involved. They recently did a structured negotiation, not just making their website accessible, but bringing in the vendor who does the platform for all the credit unions. And everyone listening to this knows that vendors and third parties play a role in all of this. And the more you can bring everybody to a round table, which is, again, an advantage of structured negotiation, the better results you're going to have. And other structured negotiation win-wins, like I call them lawsuit wins, structured negotiation win-wins. Bank America, we talked about. Lyft did a structured negotiation on their service animal policy. The Motley Fool recently committed to their website and mobile app accessibility. I'm kind of saying web as a shorthand for web and mobile. Our case with Major League Baseball, when we first wrote to them, the App Store opened, I think, in July of 2008. So we first started working with MLB in 2007, excuse me, and apps weren't on the radar, but as soon as apps came in, Major League Baseball stepped up and also has a great accessibility initiative on their apps. E-Trade has been a wonderful negotiating partner on their trading platform and their app, again, spearheaded by two blind investors. So when, you know, taking the law out of your pocket, the law is really about people using rights that we have in this country and around the world to participate. And all of these cases, I have the pictures here of the companies, but really they're about the people. Bank of America, our most recent agreement was on behalf of a blind mortgage holder, and the mortgage information wasn't accessible. And Bank of America stepped right up in structured negotiation, and having the blind advocate who owned her own home and wasn't getting what she needed in terms of information, that made all the difference. So, and again, like I said, there's more in the book. So laws and strategies equal results. In all these cases, the Justice Department, the litigation, and the structured negotiation have created accessibility rights to education, to finance, movies, sports, transportation. I've done a structured negotiation with lawyers in Texas on the Houston Metro and making sure their web and mobile were accessible. Voting, healthcare, work, and public information. Do I have another one there? No. So that's how I used to do that slide, but then I realized it's better to say, and I'm more focused on civil rights, to say these are digital access rights for students. It's all about people. No matter what role you're in, it's really at bottom the rights of people, students, homeowners, like I just said, the B of A, movie fans. We did a great structured negotiation with Cinemark on that. Sports fans, transit riders, voters, patients. We've done structured negotiations with hospitals to make sure their websites and patient information is accessible, employees and citizens. So I have a slide here, DNA, because when we work with a company in structured negotiation, our real goal is that to make access stick, to bake the accessibility into the DNA of a company. Many of you listening on here have companies with baked-in accessibility that haven't needed the law to make that happen. But good legal strategies can make accessibility stick, and the law has really helped. Again, it's not the only tool, but the law has helped make accessibility stick. So all structured negotiation agreements are the result of settlements, because we don't file lawsuits, we do negotiations and establish relations. But even the lawsuits typically end up at the negotiating table, so including with the Department of Justice or with private parties. So the best agreements have elements. I'm going to give you now the list of the elements, which really is like a best practice list. You won't find every single one of these elements in every single one of the agreements, but the law has been useful getting these elements into some agreements, and this serves as, like I say, the best practice for a legal settlement. Making sure that the settlement covers web, covers mobile, and whatever other technology is involved. If there's kiosks, if there's learning platforms, just really trying to get the companies to think, okay, we're working on this, but let's take it up to the balcony and let's look globally. Where else can we apply these principles? We always use WCAG 2.0 AA as a standard. Of course, I got nervous to know that there's now going to be a 2.1, but my nervousness dissipated because I understand that the 2.1, there will be changes to WCAG, but WCAG 2.0 AA will be stable. And so as soon as there's any new success criteria in 2.1, we can try to incorporate those in the legal agreements. The agreements call for a web accessibility coordinator. Where it should live is a really important topic we don't have time to get into here, but we try to work with the organizations we're working with and say, well, you tell us where is the best place for the web accessibility coordinator. My one thing is like, keep it out of the law office, because I think laws have played an important role in accessibility, and I'm proud that I've been able to have a piece of that, and all these strategies have worked. But the truth is, accessibility would be better without lawyers involved anywhere, because it can be creative and just making the product more usable, more. We all know the reasons accessibility improves SEO, all of those things. So it's best not to have the web accessibility coordinator in the law office or the risk management office, because it makes you think of accessibility as like, oh, something to check off so you don't get sued. And accessibility really shouldn't be that. It should be, oh, wow, we get to do this. And the law even supports us to make our products and services more available to more people. And isn't that great? So let's keep the web accessibility coordinators out of the law offices, law departments. Having an independent consultant when one is needed, training, all staff training. You all know that, it's not just the coders that need training, it's everyone. And there's so many, I'm sure you've had sessions on that at ID24, and there's been great stuff written about how to do training of everyone who touches accessibility and how to make everyone aware that accessibility is a thing that your product and service touches. So we try to highlight that in our agreements, the training. Adding to performance evaluations, I haven't yet been able to put that in one of the agreements I've negotiated, but there are agreements out there that say, if you're responsible for accessibility, that's something you're going to be evaluated on, just like you're evaluated on other things. Make sure to have a policy and a homepage accessibility information page. I'm a very big believer on this. On my website, I do have a link. If you go to the site lflegal.com and you search the word Hitachi, that company, you'll pull up the posts, which I try to keep updated, of accessibility information pages. And it goes along with my philosophy that accessibility is something not to be afraid of. Don't hide it in the corner. And I know some of the law departments are like, oh, we shouldn't say anything because we haven't done enough. In my experience, again, this is not legal advice, in my experience, the more you can talk about your accessibility, have a good phone number on that page, have a good email that gets answered, fix the problems. Blind people, disabled people, they don't want to be in lawsuits. They don't want to do lawsuits to get accessibility. They want seamless, and they want to be able to seamlessly use whatever you're providing. So make it easy for people to know what you're doing, what commitment you have, and how to pull up any problems and report them. Usability testing, use a testing tool, and make sure the vendor contracts are very specific about the requirements for accessibility. So the law has been able to integrate this into many of the companies and organizations, government agencies that we've worked with. So what kind of challenges are we facing? Because we do not have an easy job, all of us who want to just talk about civil rights and don't want to talk about the fear of the law. Because the law is really used as a tool of fear. And that's a reality. I'd rather stop my presentation right here and ask for questions on a high note, but I feel that would be irresponsible not to mention it. There are a lot of lawsuits being filed. There are more lawsuits being filed in the last couple of years than there have been the whole time I've been working in this space since, like I said, the mid-90s. And of course, media and defense lawyers like to cover lawsuits. Often in an audience, I'll ask a question, how many people knew that Major League Baseball had an accessibility commitment? Well, people don't know because, and I write about this in the book, that when people collaborate and work together, it's not really press-worthy. So you're hearing more about lawsuits, and in fact, there's more lawsuits filed. I have a picture here of a roller coaster because I guess the message that I want to leave on about these lawsuits is you're going to hear about a lot of them. And in some cases, accessibility will win. And in some cases, the case will be lost. But I don't want to say accessibility will be lost. And I think I just want to say, let's not be afraid of all these lawsuits because the foundation is so strong. And the fact that some company might win a lawsuit filed by someone new in the space who may not be as skilled, that doesn't mean that the foundation is going to go away and these other strategies are going to go away, and et cetera. So let's talk a little bit about that. We have lots of lawyers, plus, jumping on the bandwagon. I have a picture here of a cartoon band in a wagon being pulled by a horse. There's new plaintiffs lawyers. That means there's new defense lawyers. The companies that I work with, they have lawyers, of course, and every one of them I've been able to negotiate in good faith with. And the vast majority of lawyers working for these companies are into problem solving. But just as we have new plaintiffs lawyers who are filing a lot of lawsuits, we have new defense lawyers coming into the space, trying to get more business. If any of you, and I know this will be recorded, if people end up with a demand letter and need to talk to a lawyer, make sure you interview a few people and decide who is going to fit best. And many of the lawyers I work with, I can really highly recommend to companies. But there's new lawyers on both sides jumping on the bandwagon. There's new consulting firms jumping on the bandwagon. I got an email from somebody, some company, like, I guarantee I'll give you this printout and you can use it in your demand letters. I mean, there's a lot of new players here, and we can't let them freak us out and detract from the civil rights issue that's in front of us. So who's getting sued? A lot of people are getting sued. Ben & Jerry's, Best Buy, McDonald's, Domino's Pizza. These are things you're going to hear about. Other companies as well, Winn-Dixie, and there are others. And it's just good to know that it's out there. Kind of inoculate yourself. Yeah, there are lawsuits, but there's a couple big picture things to remember. Some courts are saying that websites, you can't sue about a website that's not connected to a physical space. And by connected, I mean they have this thing called a nexus. So I have this picture interwoven. Like if you can use a website like Starbucks, for example, if you can use a website to find the physical stores, well, that shows that they're connected. So some courts are saying you have to have that connection to the physical place under the ADA. And again, there's all those other foundational laws. This is just under the ADA. There's some courts that are saying that, but other courts are saying you don't need it. So you have the Netflix case, for example, streaming. It's not connected to any physical place. So what that a court says you need a connection, because you have to have one website, and other places you don't need the connection. So you need to have accessibility, and don't get freaked out about some of these courts being very kind of old school in their interpretations. Big picture number two, some courts are saying that the defendant has to pay the fees of the plaintiff's lawyers in some of these cases that we might think were, slapdashedly put together. Some courts are saying that a phone might be good enough if a website is not accessible. We don't have any higher court saying that. We have just a suggestion in a lower court. And the reason I'm telling you this, I would rather not tell you this, but it's not, we need to know it because we know it's not an excuse for accessibility, because what one court might do in the Southern District of Florida has no bearing on anyone except the parties to that case. And the foundational laws and the other strategies and the groundwork we've laid down for the last 15 years can't be undone by one judge in one district who says a phone might be enough. And that's all that's been said so far. Big picture three, don't be distracted by court losses, because the foundation is strong and the law leads to access like this road. And what is the best strategy? It's to be proactive, because the best defense to any of these lawsuits is a good offense. And a good offense are the best practices. So I just put up here the same things I said before. Make sure you have a policy that applies to all technology. Use WCAG 2.0 as a standard. Have an accessibility coordinator in a place where they can really make a difference. Use a consultant when you need it. Do training. I should have that 5 times. Training. Post a policy. Post a homepage accessibility information page. Make sure the phone number works, the email gets answered. And that is really every single structured negotiation, every single case that I'm aware of starts with blind people actually trying to fix a problem themselves. So use a testing tool, do usability testing, and make sure you check the vendor contract. So can we change how we talk about the law, even though we have all these new players jumping on the bandwagon? And when I say all these, there's a couple of law firms that are filing a lot of cases. And we already have procedures in the US court system to rein in people who are abusing the law. We have to be so careful, those of us, like all of us on this listening right now, we're committed to web accessibility. We cannot throw the legal baby out with the legal bathwater. And any time you hear about any effort to limit the ADA, we have to have a notice requirement. Well, you know what? We don't need a notice requirement, because we already have ways to limit these actors who might not be using the law in the best way. And think about the Netflix case or the Scribed case, where sort of the Netflix of books, was held to be accessible. So think of all the good that the law has done, and can we change the way the law is talked about? I'll leave you with this quote from a Zen priest from the 1600s: "In singing and dancing is the voice of the law." His name was Haikun Ekaku. He died in 1769. I have it illustrated with a picture of dancers from the Axis Dance Company. The center dancer is using a wheelchair. So if you want more law, Laura Carlson does great higher education updates. I do my updates. The Safe Arts Shaw blog does a lot of metrics about who's filing lawsuits and where. They report on the wins and the losses. Don't get freaked out by the losses, because big picture, it doesn't matter. I invite you to check out my book, which is on Amazon, and to stay in touch with me. So back to you, TPG.
Thank you very much for a great talk. We've got some questions for you. The first one is from TPG's very own Sarah Horton. When a company responds with an accessibility program to change culture and practice, what effect does that have on a lawsuit?
I think that, okay, first of all, I need to say again here that when you get a lawsuit or you get one of these demand letters, it's very important to get legal advice. And I'm not giving that legal advice here. But I do know that there's not a judge in the country who is going to create problems for a company with a commitment. And that's why one of the reasons I think people should be publicizing their commitments, so they can show, not that we just slapped together a policy the day we got the demand letter, but that, starting in this date, here's what we did. We were at CSUN. We did this usability testing. Here's what we're doing. Put it on the website. Make that part of your first legal response. I mean, there have been no cases where a judge has said, too bad, you had this great accessibility policy, but you missed this one WCAG criteria that somebody found in an automated scan, boom. That doesn't happen.
Okay, question 2. Also from one of my colleagues in TPG, all of them are in fact. This is from Henny Swan. Are there techniques from structured negotiation that we can use outside of the law to help get buy-in to accessibility?
That's a good question. I mean, one thing that's coming to mind, first off, is when I structure negotiation, instead of starting with a legal complaint, it starts with a letter. And in the chapter in my book about the letter, I say it's really important to say something good about the person you're writing to. Because even though they've screwed up on accessibility or whatever, there's something about them that's good. And one way to find that is, first of all, I always ask my clients, do they do good customer service? And I always, you have great customer service. This is part of customer service. Check the website, see how the institution, and if you're working there, how does the organization see itself? Do they care about securing the privacy of their customers? Well, without accessibility, there's no privacy. Are they big on customer service? When we did a deal with American Cancer Society, we pointed to their own words about how they're so proud that they give cancer information in like 25 different languages. So in that case, we focused on, accessibility is, in this context, it's like a language. You're so happy you're providing information in French and Russian and Spanish, you got to provide it in Braille and online accessibility and WCAG compliant website. So I think that's a real reason structured negotiation has been effective, because we don't come in with a hammer and tell people how bad they are. We talk about the value of their service and product to the customer. They want to stay with the particular bank or insurance company, but to do so, they need the accessibility. So that, and also I have a whole chapter on the meetings we've had, and honestly, it's just like usability testing. Whenever possible, I try to have someone with a Braille display come to the meeting, because when, you know, even people who think they know, they don't really get the Braille display. And to watch it in action, it can really, you can see the light bulbs go off. So a lot of the things we've done in the structured negotiation meetings, like Charles Schwab, they've been a great partner with us. It was one options trader, one blind woman, and we had a big meeting at Schwab, and they were so, you know, gracious and open, and she brought her computer. It had JAWS on it, it had the Braille display, and everyone was just like, they just wanted to fix it then and there, because when you sit, you know, show, don't tell. And lawyers, you know, are so big on telling, blah, blah, write this, write that. So, yeah.
That's great. I think we could carry on asking questions for another half hour, but that is the end of this particular session. Thank you so much, Lainey. That's absolutely fantastic to have you involved. And yeah, we'll be back in 10 minutes for our next session.
All right. Thank you all. Bye.
Thanks, Lainey.
Bye.
Thanks, Lainey.